Good afternoon. Welcome to the Analyst. Today we'll be taking up 5 newspaper articles from the Hindu and the Indian Express and discussing them. The handout for the same will be available in the description of this video for your kind perusal. Please have a look at that. Now the first article that we'll be talking about is related to disinformation, as it is being used like a weapon on the social media platforms and is a major threat to democracy. The second article is related to All India Judicial Service, as President Draupadi Murmu has called for an All India Judicial Service for the recruitment of judges. The third article is related to adultery, as the Parliamentary Standing Committee on Home Affairs has recommended for the criminalization of adultery on gender neutral lines. The fourth article is related to coal sector, as India did not endorse a renewable energy pledge at the COP28, as it had a reference to the phase out of coal and for no fresh investments in the coal sector. The final article is related to the Monetary Policy Committee and the repo rate, as the MPC is expected to keep the key lending rate unchanged at 6.5%. Now the first article is related to disinformation, as disinformation has been scaled up and weaponized on social media platforms, and it is like a major threat to democracy, as was also observed during the 5th World Media Summit in China, and it affects the media credibility too. This is important in the paper GS2 in governance and also in GS4 ethics, as media ethics is an important topic there. Now, if you observe the incidents, as has been the trend of late in India as well as globally, there are a lot of disinformation campaigns, misinformation, false propaganda, etc. For example, if you observe in India, in the case of Tamil Nadu, in February, March this year itself, there was a propaganda that there is violence against the Bihari migrant laborers in the state of Tamil Nadu, and there are even murders. It was essentially to spur an exodus of Bihari laborers from the state of Tamil Nadu. Likewise has been the case globally also. For example, in the US presidential election of 2016, there was a mass hatred which was being spread against certain sections. It was essentially to sway the voters to vote for certain parties. Likewise was the case in the case of Brexit referendum, essentially again to sway the voters in a certain direction. Likewise was the case in the referendum of Colombia in 2018 also. So what is essentially fake news? What is that disinformation? Fake news is any news which is false, fabricated. Usually it is intentional. It is intentionally generated some information which cannot be verified. There are no facts behind it. Those facts which are claimed in that news, they are not verifiable. The sources are not credible, and hence it leads to a kind of a propaganda, and those quotes which are given, they are not verifiable again. It is essentially sensational. Sometimes it is to attract clickbaits, it is to attract that financial or monetary gain by giving out misleading advertisements, such as is the pattern in dark patterns, etc. also. And sometimes it is to ensure that desirable political outcomes are achieved. For example, through social engineering, for example, for the mass influencing of voters during the times of elections, etc. Or giving false headlines, essentially to capture the attention, to capture the imagination of the audience. And what are the types of fake news? If you observe, it can be in the form of a satire or a parody. Essentially, these do not cause harm. They are for the purpose of humor, etc. But sometimes they are harmful also. For example, in the form of misleading content, misleading advertisement, imposter content, which even leads to breach of right to privacy, and false, fabricated and manipulated content, etc. So how is it harmful? What are the negative implications of the disinformation campaigns? One, it has the potential to unfairly manipulate. Manipulate for certain desirable outcomes. It can be in the form of social outcomes. It can be in the form of inciting of communal hatred to promote enmity among sections of the society. Or it can be in the form of political outcomes. For example, vote bank politics influencing voters. Or it can be in the form of swaying votes, and essentially in that social media emerges as one of the top contenders through which the platform is used for spreading that false news, for spreading that disinformation, etc. Now, what are the measures to limit that disinformation? Let's talk about India first. In India, usually there is little debate around curbing of disinformation till now. Usually we go for knee-jerk measures, knee-jerk responses. For example, Whenever there is a mass violence in a certain area, we go for internet shutdowns. For example, as was observed in the case of Manipur also, we just go for an internet shutdown. Now that even disregards the doctrine of proportionality also. What is doctrine of proportionality? It essentially means that when we are going to restrict the fundamental rights of a citizen, then that restriction should be proportional to the stated objective that we are trying to achieve. The purpose behind that restriction, that should be sufficiently important to warrant that restriction. But that is not the case often, because internet shutdown, that is like an extreme measure just to check disinformation. Rather than that, there can be other measures like maybe setting up fact check units, etc., or bringing in social media intermediaries responsibility to check that spread of disinformation. And also, as per the doctrine of proportionality, if there is a restriction, there should be minimal infringement upon that fundamental right, upon that right to freedom of speech and expression. Plus, these knee-jerk reactions, they are oversimplistic, and at times they are non-transparent also, and it can be termed as even autocratic, because it is the government who itself decides what is important and why internet shutdown is required, and is the situation so dire. Then it at times gives greater powers to itself. The government gives greater powers to itself to strike down any unpalatable content, any content which is not desirable. For example, if you observe the section 69A of the Information Technology Act 2000, as per this section, the government can take down any content. It can check any information if it deems that information to be against the sovereignty and integrity of the state, if it is against the security of the state, if it disrupts the public order. So it is an unchecked power also, it is claimed by certain sections. Likewise, it has come up with the IT Rules 2021. These are the intermediary guidelines and digital media ethics code. It is essentially to regulate the content which is hosted by the social media platforms usually. That is the main focus of these rules. And it is essentially to make sure that the intermediaries, they are held responsible. They are supposed to publish their privacy policy. They are supposed to publish the terms of use of their platform, like what kind of content can be hosted, and they are duty bound to remove any unlawful content. And the recent amendments to these IT rules in 2022 and 2023 have empowered the PIB to flag inaccurate and fake news related to government bodies on social media platforms. But it has been often been criticized as a measure to curb criticism against the union government, and it is alleged that this amounts to curbing of dissent. Again, dissent is required in a democracy. The voices against the government, they should also not be suppressed. Then a fact check unit under PIB is also being set up. Now this fact check unit will have the powers. It can take cognizance suo motu also, or it can take cognizance of fake content upon receiving of queries by citizens who are asking questions regarding the content which is flagged. Plus, the Ministry of Information and Technology, that has come up with a program, Information Security, Education and Awareness. Plus, the Broadcasting Content Complaint Council. This is empowered to admit complaints against the content which is being broadcasted by TV channels, etc., if it is spreading fake content, misinformation, misleading campaigns, misleading advertisements, etc. What are the measures which are taken globally? For example, in the case of European Union, it came up with a code of practice on disinformation in 2022. Now, this code of practice on disinformation was put in place after extensive consultation with the stakeholders involving the public also, the social media intermediaries, companies, etc. And it puts in place measures like ensuring transparency in political advertising, ensuring empowerment of fact checkers and researchers, and coming up with more tools to flag disinformation, etc. Also, in the case of UK, it has come up with an online safety bill. Now, this bill is essentially to put the responsibility upon the social media platforms, the intermediaries, to monitor the content which is problematic. But these social media intermediaries, for example, WhatsApp, Signal, etc., they have claimed that the bill of UK, the online safety bill, it will lead to breach of right to privacy of the citizens if the social media intermediaries, they are monitoring that content which is so-called hate content or so-called fake content by the government. Now let's take the case of Tamil Nadu. The Tamil Nadu government, after the recent incident, set up a fact check unit. Now this fact check unit, its constitutionality is being questioned because it is alleged that it will lead to the violation of some fundamental rights. For example, it will have a chilling effect on the right to freedom of speech and expression contained under Article 19, subclause 1, subclause A of the Indian Constitution. Because the right to freedom of speech and expression, it can be curtailed only on the basis of reasonable restrictions which are contained under Article 19 subclause 2. No other ground can be given for the restriction of this fundamental right. Now, public interest is not even a ground which is contained under Article 19 subclause 2. Plus the restriction under Article 19 subclause 2 that can be imposed by the government by way of a law, by way of enacting a law. It cannot be done by simply passing a government order as the government of Tamil Nadu did. Also, the unconstitutionality is being proven on the grounds that it is vague and arbitrary. For example, it says that any information related to government of Tamil Nadu, although the purpose of setting up the fact check unit by the government of Tamil Nadu, it is said that it is to check the hate content, etc. But does it amount to hate content if it is related to any information related to the government of Tamil Nadu? And also, if there is an economic critic or if there is investigative journalism, will it also be subject to the jurisdiction of the fact check unit which is being set up? Likewise, there are procedural irregularities also which are being claimed. For example, there is no provision for an opportunity of hearing for the individuals whose content is being subject to fact checking. There is no opportunity of hearing, and through the principle of odi alteram partem, unless both parties are being heard, then the procedure is not fair. Therefore, the government acts like the judge, jury and the executioner without the due process of law being followed here. Likewise, there is a misalignment of the government order with the stated objectives also. For example, the hate speech has no direct nexus with information related to the government of Tamil Nadu. Also, there are no consultations with the stakeholders. It should have been done prior to putting the fact check unit in place. There should have been consultation with the public also and with the intermediaries also. Now, what are the steps which are being taken up by India to curb such fake news, disinformation, etc.? Let's talk about the legislations first, which are in place to curb the fake news. First, the IT Act. The Information Technology Act, as per section 66D, also the spread of misinformation, disinformation can be curbed. Section 66D essentially is to check the cheating by way of personation by using somebody's computer resource. Such form of electronic communication is an offense as per section 66D of the IT Act. Likewise, as per the Disaster Management Act also, under section 54 of the Disaster Management Act, if any person spreads fake news regarding the severity, the impact, the damage that is caused by a natural disaster, etc., then he is also liable to punishment. Also, there are provisions under the Indian Penal Code regarding spread of misinformation, disinformation, etc. For example, under section 153A of the IPC, if a person is spreading enmity among groups, religious groups, caste groups, etc. on any grounds, then he is punishable. And also under section 295A, if any person is saying such content or by way of words spoken or written or by way of actions, he ends up outraging the feelings of any religious group, any community, etc. Again, this is a punishable offense. Or under section 499, defamation is also an offense. Now, what are the Supreme Court judgments regarding the curbing of disinformation? The recent judgments, for example, the Alak Alok Srivastava versus Union of India, this was a judgment in the case of a PIL which was filed because of the plight of the migrant workers who had to walk back home during the first lockdown, during the first COVID-19 lockdown. There the court observed that it will be a danger to the public order if there is a dissemination of fake news. Therefore, it has to be curbed, and it is the duty of the state and the central governments to curb this fake news. Likewise, in Tehseen Poonawalla versus Union of India case, the court observed that it is the duty of the government to curb dissemination of irresponsible and explosive messages which have such content which is likely to incite either mob violence or lynching of any kind. Therefore, it is essentially the duty of the center as well as the state governments. Now, what is the way forward? How can this menace be curbed? One, we can go ahead with media and digital literacy campaigns, essentially to make sure that the citizens are aware, and we can partner with the local news groups also to educate citizens on how to identify the real news, how to differentiate between real news and fake news. Plus, there should be measures to ensure quick prosecution. There can be judicial reforms also, and there can be strengthening of the state prosecution machinery. There can be strengthening of the state police machinery also to catch the culprits who are behind the spreading of misinformation and disinformation. We can explore imposing hefty fines like Germany, who imposes hefty fines on social media companies if they fail to remove any illegal content which is hosted on their platforms. Plus, the print and electronic media both, they can explore having an internal ombudsman to ensure that there are internal checks and balances to ensure there is no disinformation campaign, etc. The second article is related to All India Judicial Services. The context behind it is that President Draupadi Murmu called for an All India Judicial Service for the recruitment of judges. This is important in the topic judiciary in GS2. Now, how are judges in the subordinate judiciary and district judges selected as of now? Currently, the governor appoints the district judges and the judges in the subordinate judiciary on the advice of the Chief Justice of the High Court of the respective state. Now, Law Commission of India in its 14th report in the 1950s for the first time recommended for the establishment of an All India Judicial Services. Now, how will it work under the All India Judicial Service? The district judges can be recruited centrally through an All India examination, and then they can be allocated to the states like an All India service like IAS, IPS, etc. Thus, the recruitment can be through an All India examination. After that, there will be allocation like a cadre system to the states. Now, let's look at the procedure first regarding the setting up of All India service. The 42nd Constitutional Amendment in 1976 amended Article 312 subclause 1 of the Indian Constitution. It amended it to read as that the Rajya Sabha can pass a resolution for the setting up of a new All India service. The Rajya Sabha will be passing this resolution through a special majority, that is 2/3 of the members of Rajya Sabha present and voting will have to vote in favor of setting up a new All India service. After this is done, then an amendment will be required under Articles 233 and 234, and the recruitment and conditions will be regulated by the Parliament. Therefore, that All India Service Act of 1951 will come into picture. Thus, no amendment to the Constitution will be required under Article 368. A new All India Service can be put in place through Article 312 subclause 1 itself. Now, what are the arguments in favor of having a system of All India Judicial Service in place? First, if we look at the Law Commission of India report, 116th report, it observed that we should have 50 judges per million population in India. At the time of the Law Commission of India report, there were only 11 judges per million population. Right now, there are about 21 judges per million population in India. Whereas, if we look at the global standards, in USA, there are 107 judges per million population. In UK, there are 51 judges per million population. And if you look at the actual strength, the working strength of the subordinate judiciary is about 20,000 judges only, even lesser than the sanctioned strength. The sanctioned strength is also 25,000 approximately. Therefore, 5,000 posts are vacant even out of the sanctioned strength also. So, to improve this judge to population ratio, an All India Judicial Service will help. Second, when we look at the pendency of cases, there are more than 5 crore cases pending in India. And 85% of the cases, that is 4.3 crore cases, are pending in the subordinate judiciary itself, and more than 1 lakh cases are pending for over 30 years. And if you observe the NCMS report, the National Court Monitoring System report, this report is about a decade old. It was published in 2012. It observed that in the next 3 decades, we will be needing about 75,000 judges. Next, there is an absence of career growth. There are less than 25% chances of being elevated of the district judges to the High Court level. About 75% of the High Court judges, they are selected directly from the bar. Thus, the appointments in High Courts, they are mostly from the bar directly to the bench. Plus, it will help in having a talent pool. and that pool will have a younger age profile, and it will help in attracting the best talent in the Indian judicial system. If you look at it internationally, France also has a career judicial service. Then Law Commission of India reports 14th report, 77th report and 116th report have also recommended for the setting up of an all India judicial service. Now this all India Judicial Service will also ensure more accountability and equitability in the Indian judicial services, particularly in the subordinate judiciary. Next, let's look at the arguments against an All India Judicial Service. Some arguments were put forward by a report by the Vidhi Center for Legal Policy. As per this report, the judicial independence of district judges might be affected if we put into place an All India Judicial Service. For example, right now the High Court has a significant role in the appointment, removal, transfer, etc. of the district judges and the judges of the subordinate judiciary. But if we have an All India Judicial Service, as per the Law Commission of India report, 116th report, a National Judicial Service Commission may also be put in place. Now this commission will consist of retired or sitting judges of the Supreme Court or members of bar and legal academics or eminent jurists, etc. Thus, it might lead to the concentration of such powers, the powers regarding the appointment, transfer, removal, etc. of the district judges in the hands of a few. This might lead to this concentration of power, or there can be concerns regarding the representation of marginalized communities. For example, certain communities which are recognized as OBCs in the state list, they will not be in the central list sometimes, and they will say that we are not represented if the All India Judicial Service is put into place. There might be language barriers also. For example, if the judges they are belonging to a different state, they might not know the language of that particular state, and if they do not know the language of that particular state, there will be concerns because the district judiciary usually works in the vernacular languages, etc. For example, in the northern states, Hindi is usually used in the lower judicial system. Now, what can be the way forward? The way forward can be a broad consensus has to be built first. A consensus has to be arrived between the union government, the state governments, as well as the judiciary. For example, the high courts of several states actually agree for having an all India judicial services, but most of them disagree, fearing that there can be a loss of power. In the meantime, we can explore more direct solutions to the judicial problems. For example, setting up e-courts, etc. or fast-track courts, etc. Now, the next article is on adultery. The context behind it is that the Parliamentary Standing Committee on Home Affairs has recommended the criminalization of adultery on gender-neutral lines. This is important in the paper GS2 in the topic governance. Now, what is adultery? Adultery is voluntary sexual intercourse by a married person with a partner other than his or her spouse. That is essentially adultery. Now, what was the legal position regarding adultery in India? Before the Supreme Court judgment of 2018, the judgment of Joseph Shine versus Union of India, adultery was a criminal offence under section 497 of the IPC. What does 497 of IPC say? It says that it is a criminal offence for a man to have sexual intercourse with a married woman without the consent of her husband. Therefore, in this case, only men could be punished under section 497, not women, first thing, and wife shall not be punishable as an abettor. So this was not a gender neutral provision. Therefore, if the man has the consent of the women whose husband gives the consent for sexual intercourse with that particular woman, then that adultery will not be a criminal offence. Plus, the wife could not prosecute her husband if he was committing adultery with the consent of another woman whose husband was giving consent. Therefore, this was not gender neutral. Now, what did the case of Joseph Shine versus Union of India say? In this case, the court observed that this section 497, it is discriminatory and it is violating several fundamental rights, including articles 14, 15 and 21. How article 14? Because the men and women, they should be treated equally. And under article 15, the discrimination is not allowed only on the grounds of race, religion, sex, etc. Here the discrimination is being done on the grounds of sex. Likewise, it is violative of article 21 also. Article 21 is regarding the right to life and liberty. Now, right to freedom of choice and right to sexual autonomy is also a part of Article 21, particularly after the right to privacy judgment, the Puttaswamy judgment. Therefore, the court observed that the autonomy of women as a facet of human dignity is in question. Therefore, section 497 was struck down, and husband is not a master of his wife, nor does husband have a legal sovereignty over her. Therefore, it has to be termed as discriminatory. Secondly, it does not even fit into the concept of crime as per the observation of the court, because it is amounting to an intrusion into the extreme privacy of the matrimonial sphere. How? It is offending two facets of Article 21. For example, the dignity of the husband or the wife, as the case may be, who is committing adultery, and also the privacy which is attached to the relationship between the two. Therefore, it was struck down. Plus, section 497 was replete with anomalies. For example, the wife cannot prosecute the husband who is committing adultery. Now, what did the Parliamentary Standing Committee recommend? It said that the offense of adultery can be reinstated like a crime. Now it can be made as gender neutral. The section 497 had reduced the married woman like a property of the husband. But the Parliamentary Standing Committee observed that the institution of marriage in India, this is considered sacred. This is sacred in the Indian society, and there is a need to safeguard its sanctity. Therefore, adultery should be made a criminal offense, but this time it can be done on gender neutral lines. Therefore, it observed that earlier it was struck down essentially on the grounds of discrimination. It can be reinstated this time, removing that discrimination. Now let's look at some aspects regarding adultery again. After the judgment of 2018, the center had sought a clarification from the Supreme Court whether it will be applicable in the case of armed forces also, because usually the culture in armed forces is that this has to be prosecuted like a criminal offense. There the court observed that there the discipline is of paramount importance, therefore the government can go ahead and prosecute them. But can the Supreme Court's decision in this case be undone simply? Essentially, the observation of Supreme Court, usually a ruling of the Supreme Court, is considered as the law of the land. It cannot be in the usual circumstances overturned by the Parliament by enacting a different legislation. But the Parliament can pass a law if it is removing the very basis of that court's judgment. Here the basis of the court's judgment was that the section is discriminatory. The section 497 is discriminatory, it is not gender neutral. Now if that is removed, will it be valid now? Such a law can be actually both retrospective and prospective. Now in the case of Madras Bar Association versus Union of India, it was observed that if you want to decide, if you want to check if a law fixing a problem is valid, then one need to see if the court's decision would have been the same if the corrected situation existed when the judgment was made. Therefore, now the situation will be different because the provision will be made as gender neutral. On this basis, the Parliamentary Standing Committee on Home Affairs has recommended that it can be made as a criminal offence again, but it will be gender neutral. Now, the next article is related to the coal sector. The context behind it is that India did not endorse a renewable energy pledge at the COP28, as it had a reference for the phase out of the coal and also a suggestion to end fresh investments in the coal sector. This is important in the paper GS3 in climate change as well as the energy needs etc. of India. Now let's talk about the coal sector in general first. What is the scenario in India? India has the fourth largest coal reserve. India is the second biggest producer of coal in the world, and the world's biggest coal miner, the company Coal India, is making up for the 80% of the domestic output of coal. Also, more than 75% of India's energy needs, India's power is met from coal, and the mineable capacity of already allocated coal blocks is actually more than which is being done right now. Now, let's look at the history of coal sector also before coming on to the arguments in favor of rather increasing coal production in India. Historically looking, in 1774, for the first time, commercial exploitation was started in India, the commercial exploitation of coal through the Raniganj coal field in West Bengal. It was done by the East India Company. Now, after independence, we started reforms. In 1956, the National Coal Development Corporation was put into place. But through the Coal Mines Nationalization Act 1973, all the coal mines were nationalized. Therefore, the private sector could not indulge in the mining of coal. But this was appealed in 2018 and the re-entry of private players was allowed in the coal sector through Coal Mines Special Provisions Act 2015. Now, why was it allowed? Essentially to promote competition also, to promote efficiency in the production of coal also, to increase domestic production of coal also, and to meet the energy needs of India. Now, this re-entry of private players, it was to be done through auctioning of coal mines on the basis of offer of highest price per ton of coal which is mined by such private miners. In 2020, we also put in place a national coal index. Why? Because the WPI of coal does not take into account the imported coal. Therefore, we had to put in place a national coal index. This serves like a benchmark for the revenue sharing contracts being executed after the auctions for commercial mining of coal, and it reflects the change in price of coal in a particular month relative to the fixed base year of 2017-2018. Now, if you observe globally, the prices of coal have been increasing. Therefore, the national coal index that has been jumping, but the WPI for coal, the wholesale price index for coal, that has remained stable because the domestic price of coal that has not increased. Now, why do we need to increase rather of the domestic production of coal? One, there is often a spike in the global prices, as has been the trend recently. For example, the national coal index that has increased, whereas the WPI for coal that has remained stable. Therefore, we need to increase the domestic production. Also, we need to ease the inflationary pressures. For example, India needs cheap and affordable energy, and that energy will come from coal for the foreseeable future, and that cheap energy is required to ensure that inflation remains in check and we are on a fast and sustainable economic growth path. Plus, we need to shield the domestic economy because the prices in the international market, they are volatile, and it will lead to reduced cost. For example, the domestically produced coal, that is 5 times cheaper than the imported coal. Plus, it will have a ripple effect. For example, the energy revenue, the total energy revenue which the government accrues from various sources, almost 80% of it comes from the fossil fuels like oil and gas sector. About 15-16% comes from the coal generated electricity, less than 1% comes from the renewable energy sector. And the local economies will be adversely affected. There will be cascading impacts if the local economies, if the coal mines are closed. It will affect the local employment, etc. Plus, there is an excessive focus on the renewables. For example, we have already increased our renewable energies target. Initially, we were supposed to achieve 150 gigawatt of renewable energy by 2030. We increased it to 500 gigawatts. We have also committed to the net zero pledge by 2070 also. It will lead to an increased fiscal burden, but because we will need to invest about 20 to 27 billion dollars per year to achieve these renewable energy targets, therefore we need to have a structured path. This path for transition from coal to renewables, it has to be gradual. There has to be an orderly transition, and there is a hypocrisy by the rich countries. For example, if we observe the case of Germany, it is one of the worst examples. Like, one third of the energy which is produced in Germany comes from the coal sector. Now it started closing down its nuclear plants also, therefore its dependence even increased on coal even more. Plus, it uses mostly domestically produced coal, which is lignite in Germany, which is one of the dirtiest forms of coal in the world. Now, what can be the way forward for India? One, sensitization. The Western countries, the financial companies, they also have to be sensitized that India will be dependent upon coal for the foreseeable future for ensuring access to cheap energy for its population. Plus, we also need to have a clear policy instruction, a set of instructions. For example, through the draft national electricity policy, we did encourage the production and usage of coal for the foreseeable future. Plus, we need to have a regulator. This regulator might serve like a single point of contact for the private coal miners, etc., so that there is ease of doing business. We also need to diversify the sources of coal and ensure that the quality of coal is not poor. Plus, the cross subsidization also has to be reduced to promote the coal sector, because usually there is more tax which is imposed upon the more emitting industries like the coal sector, the oil sector, etc., whereas there is cross subsidies which are provided to the renewable sector. Plus the path has to be sustainable. Now the next article is related to the Monetary Policy Committee. This is important as the MPC of RBI is expected to keep the key lending rate, that is repo rate, unchanged at 6.5%. This is important in the topic Indian economy in GS3. Now what is the repo rate? Repo rate is the rate at which the Reserve Bank of India lends money to the commercial banks in the event of any shortfall of funds. Now what will be the impact of this decision if the MPC of RBI keeps the repo rate unchanged at 6.5%? One, it will be giving relief to the borrowers. How? For example, when the bank gives loans to the customers, to the borrowers, it charges some interest rate. That interest rate is to be linked to an external benchmark based lending rate as per the RBI guideline. Now what is that external benchmark based lending rate? It essentially means that the interest rate which is being charged by the bank, it is to be linked to either the repo rate or the 3-month treasury bill or 6-month treasury bill. There are 4 external benchmarks to which that interest rate has to be linked. Now if that repo rate is not increased, then the interest rate which will be charged from the borrowers by the bank, that will also not increase, as is the case in the case of floating rate loans, etc. Plus it will be favoring growth. Usually when the MPC determines the repo rate, it has to ensure that there is a trade-off between growth and inflation. When the repo rate is increased, then it is targeting inflation, because in that case the banks will be charging more interest rate from the consumers, and when more interest rate is charged, then people will be taking less loans or there will be less liquidity in the market, and that will be an inflation control measure. Whereas if the repo rate is decreased by the central bank, that is essentially to spur growth, to encourage the taking of loans by the consumers, etc. Therefore, it is favoring growth by keeping the repo rate unchanged at 6.5%, and many global agencies, they have been lowering the forecast for India's growth rate. This global economic slowdown is one of the factors behind this, and also the monetary tightening by the other countries. But because the other countries are tightening their monetary policy and increasing the repo rates, and Indian central bank RBI is not increasing the repo rate, therefore there is a kind of a decoupling. This decoupling of interest rate, that is maintaining our interest rate or monetary policy stance different from what has been the trend globally, this leads to a kind of a decoupling, and this will ultimately ring fencing the domestic financial stability and protecting the economic growth. Usually around the world, the developed countries, they have been increasing the repo rates, they have been increasing the central bank rates. Let's look at the Monetary Policy Committee, also a brief overview regarding this. This Monetary Policy Committee came into picture after the 2016 amendment to the RBI Act of 1934. So this is essentially giving a legislative mandate. It will be determining the policy rate. The policy rate required to achieve the inflation target, and the decision of MPC shall be binding on the bank. As per section 45ZB of the RBI Act, the central government is empowered to constitute a 6-member Monetary Policy Committee. Now, who will be the members of the Monetary Policy Committee? One, RBI Governor will remain as its ex officio chairperson. Deputy Governor will be in charge of the monetary policy, and an officer of the bank will be nominated by the central board, and 3 persons are to be appointed by the central government. Now, what will be the functions of MPC? It will be setting the policy interest rate, specifically the repo rate. It will be ensuring inflation targeting. For example, right now it takes into account the consumer price index. It is to be ensured that it remains around 4% with a target bandwidth, a tolerance band of plus minus 2%. It will be performing economic analysis and forecasting. Forecasting of what? Economic indicators including inflation, GDP growth, employment and fiscal conditions, etc. And it will be making decisions regarding the setting up of repo rates. For this, it will be meeting at least 4 times a year to take and review the monetary policy stance. Thank you.